and Rick Unger back in the chair for Steve Malzberg today here on the Steve Malzberg Show. Again, a lot of conversation about what's going on down in Ferguson, Missouri. To help us delve a little deeper into this, Dean Obeidallah, a columnist for the Daily Beast, political comedian, and a good one I might add, and former attorney. Dean, are you with us?
I am. Thanks for having me on, Rick.
There you are. How are you, Dean?
Good, thank
so
you.
you wrote a piece earlier this week that I thought was interesting. You basically predicted that Darren Wilson, the officer in the shooting, would walk. Now, I can't say that you startled anybody, because I think most of us thought that the officer would not face an indictment coming out of the grand jury. But what was your particular reason for seeing it this way?
Well, I actually wrote an article in August, a short time after the arrest, saying that it's very unlikely that he would be indicted, just given the fact and the history in America that police officers who shoot people in the line of duty are very rarely indicted, let alone convicted of anything. And in this case,
let me interrupt you to ask you, do you think that's the way it should be?
I think it should be on a case-by-case basis. I think there are good shootings and bad shootings. There are police officers who do things that we would actually overwhelmingly approve of. They're keeping us safe. They're shooting someone who's a threat. And there's other times where you really have questions about what happened. And was it right or not? And that's where you have a grand jury involved or have the adversarial proceeding in an actual trial to make that determination. So, I mean, I think there are great cops and there are a few probably bad ones or undertrained ones out there, and that mix into the whole situation. But, you know, from the African-American community, you can't deny the statistic that the chances of being killed in an encounter with a police officer goes up 3 times if you're black versus white. Those are statistics. There's something inherently wrong when those are the numbers that the FBI has collated and put together in a report that I read last year. So, you know, there's something going on. In this case, though, you know, for me, when you look at the fact the grand jury is going to have the police officer testify for over 4 hours, and I interviewed a prosecutor for my piece, a former prosecutor, who said never in the time that she was a prosecutor or a defense attorney has a police officer testified and been indicted. It just has not happened ever, 0 times. And there's a reason.
That's interesting. But, you know, I kind of want to go back to your earlier point because it fascinates me. You're absolutely right that police officers get a very strong presumption of innocence. But as an attorney, you know that every American is supposed to get a strong presumption of innocence. I think there may be some, say, in the black community who might disagree that that is their experience. But in the case of a police officer where you know that self-defense is always going to be a key issue, I'm curious how you feel about that. Should we give police officers an elevated presumption?
Well, that's a good point, because our law really is not putting people on the level playing field. Police officers are slightly more protected. It's not about innocence, it's about statutory defenses that they have. In Missouri specifically, I wrote about it. They have a statute there, which is pretty much a typical statute, saying that the officer has the right to use deadly force in effectuating arrest of someone who's suspected of a felony if they fulfill certain obligations or fulfill certain criteria, which is pretty straightforward criteria, frankly. Basically, that the suspect is believed to have committed a felony, and that the officer acted reasonably in the circumstance, and reasonably goes to reasonably fearing for the officer's life, that person is going to die. You know, we have self-defense, me and you too. If someone comes at us, we can use self-defense. It might be statutory or not, but you know, we made a decision from our law's point of view to give the police a little bit more protection because of their jobs. And the Supreme Court, in a famous case in 1985, made that exact say in Graham versus Connor. It's a famous case where they look at the police officer's job, life or death, every day. And in certain cities,
right. And don't you think that is more at the heart of what we're looking at here than maybe is being discussed? The one thing we can never do is climb inside Officer Wilson's head or anybody else's head to know exactly what he was feeling at that moment. And when you look at the evidence, and there are still some questions that some people are raising, and I have some concerns about how hard the prosecutor went after the officer when he was on the stand. But when you look at the physical evidence, the evidence presented, it is believable that Officer Wilson could have been experiencing that fear, yes?
Yes, absolutely. And that's where it comes down to. The jury, the grand jury in this case, is taking all the evidence, and they're going to say, who do I believe? Do I believe the police officer saying that Michael Brown, after the altercation, got out of the car, and then at a point Michael Brown turned around and came back at him, and the police officer feared for his life? Or are they going to believe some witnesses who said, at least one apparently, that he had hands up and that he was trying to surrender? Who do you believe? And the grand jury wasn't just impaneled for this case. This grand jury had been there for at least a month, maybe 2 months.
Right. Well before this happened.
Right. So police officers come in every day, not Darren Wilson, other police officers, and they see police officers, frankly, as their friend. They're helping them, guide them through the process. They're saying, these are the facts of the case. So they were looking at police officers as someone as very believable, very credible. So here comes this officer who's actually the subject of the investigation, which they probably have not seen in their time.
And they're inclined to believe him. Dean, I got to wrap you up. I apologize, but you do make some very good points. I hope people will spend a little bit more time looking into the issues that you're talking about. It may not be as sexy, but it certainly is important. Dean, thanks so much for joining us. Dean Obeidallah, columnist, comedian. We'll have him back. We will be back with the Malzberg panel after the break, but first, Operation Nickel Grass delivered weapons and supplies to Israel during the 1973 Yom Kippur War. Let's take a look back now at this hour's American Moment.
On October 6, 1973, while the nation of Israel observed Yom Kippur, the holiest day of the year for Jews, the combined military forces of Egypt and Syria launched a simultaneous and surprise attack on Israel's southern and northern borders. Within days, the Israeli army found itself in retreat, losing a third of its equipment and outnumbered by the enemy 3-1.
He could not believe. He said, we cannot stop them.
Recognizing their very existence was at stake, President Nixon moved quickly to resupply our ally Israel and their besieged army. With an around-the-clock airlift of U.S. military support, the tide of battle shifted, and soon the Israeli armies were advancing into both Syria and Egypt, with Israeli General Ariel Sharon's tanks threatening Egypt's Third Army with annihilation. The Soviet Union, who were supporting the Arab armies, quickly called upon President Nixon to stop the Israelis' advance or risk a larger war. The president intervened, saved the Egyptian army, and then used the opportunity to convince Egypt's President Anwar Sadat to seek a peaceful solution to a conflict that had plagued the region for decades. You're watching An American Moment on Newsmax TV.